The number you have reached, 911, has been changed to a non-published number.
Welcome to Cltv. I'm your host, Ken Lammers, and this week what we're going to do is we're going to go through my Fave 5, the 5 posts which most caught my attention from the blogs this last week. The first is from White Collar Crim Prof blog. White Collar Crime Prof blog, and it is about from a guest blogger, a gentleman by the name of John May, who writes about the federal government indicting a lawyer for having gone back and checked to see whether or not money that was paid to a separate lawyer to defend someone was illegally obtained. The first lawyer certified that it was not, and thereafter the federal government indicted him. Apparently there's some question as to what exactly the federal government thinks it's indicting him for, because they're on their third superseding indictment right now, and the first couple people were like, what's the charge here? Because apparently, now this is straight from the blog, I don't have any first-hand knowledge here, apparently there's no information which says that the money which came from Colombia, of course, to the United States into a money exchange was illegally obtained, or that anything illegally was done at all there, and it was switched to American currency, U.S. currency, and went through this lawyer's trust account, and therefore he's charged with money laundering. The government's apparent theory here is that all these exchanges are so corrupt and filled with money that comes from drugs that even if the money initially did not, it had to interact and intermingle with money that came from drugs, and therefore it was dirty when it came out of the exchange. There's got to be a better theory than that from the government. But that's the way it's explained in the blog, which is really kind of interesting. Apparently the government is also in its third indictment on this gentleman, third superseding indictment on this gentleman, decided that they're going to charge him with fraud as well, because apparently they're claiming that by the money, Colombian money leaving Colombia, that they defrauded they broke Colombian law, and therefore he should be charged with fraud in the U.S. court. Okay. That's an interesting theory. It will be interesting to see how these things play out if they're actually taken to trial. And I commend the article to you. I suggest you go read it and get a little bit more information. Our second entry for the day is from Underblog. And Underblog is talking about, he's got a client who swears that she's Smith, not Jones. No, I am Jane Smith. I am not Mary Jones. So, everybody's skeptical of these claims. He takes the client in front of the judge. The judge orders fingerprints taken from her and then compared to fingerprints of the other person. He then has to go and fight with the jail, the state lab, and it's just a all-around kind of fun story, back and forth, and ends up with a surprising ending. So I suggest you go read it and enjoy. Third, we have the Southern District of Florida blog, and he's talking about an ethical question. Apparently there was an attorney whose client had confessed a crime to him, a murder to him, but had never released the attorney, said, you can tell anybody when I die or at any other time. But there was another person serving time for the attorney's client. Another person was serving time for the crime the attorney's client did, a murder apparently. And after the attorney's client died, he then goes and tells people or tells whoever is doing the habeas or Innocence Project or whomever, Innocence Project, that, you know, his client was the one. And he gets put on the stand, and the judge warns him that if he does this, the judge is going to tell the bar, and the guy does it anyway. I understand the reason for the ethics rules. There are points where ethics are trumped by morality, and where your client is not going to be harmed, because you can't be thrown in prison once you're dead, the morality here, in my mind, clearly trumps the ethical rule. And, you know, there may be those in the state bar, in his state bar, that see it differently, but I want to say that this gentleman, whose name is Staples Hughes in North Carolina, is someone who should be applauded for what he's done. And, ladies and gentlemen, I think we all should look to ethical people like this for inspiration. Our fourth article comes from In the Moment. Now, it's not really a uplifting or happy story. In the Moment is going through a vehicular manslaughter charge, and his client is, you know, there's no wiggle room. The prosecution's not going to back away, and he is trying his best to get the guy the best deal he can during sentencing, and things don't turn out all that well. I commend the article to you and suggest that you go read and see what In the Moment's going through. And our final story today is actually one that went across several blogs. I'm only going to pick through a few, and it was kind of a meme that went on for a few days. I'm going to go start out first with the Matlock blog, where Sean Matlock is talking about, you know, the new Dallas prosecutor is pushing for it to be a crime for there have been intentional Brady violations. Now, for those of you who are not attorneys, a Brady violation, Brady requires that you turn over evidence, if you're a prosecutor, that would tend to prove a proved innocence or disprove guilt, and evidence that would tend to impeach witnesses. Now, or at least prosecution witnesses. Now, the problem with Brady is that it can be incredibly subjective. Well, I'll get into that in a minute. Matlock, Sean Matlock goes through and you imagine this. Imagine the circumstances you end up with when you pass this law into being. You know, it's a felony now to prosecute or to have not turned over Brady materials. And suddenly, you know, somebody 7 years later, 8 years later, 10 years later, gets a hold of some evidence that proves that he didn't do it, or at least puts enough doubt that some appellate court somewhere, somehow, kicks his case, and he ends up not being in prison anymore. Then the current prosecutor turns to prosecute whomever had been involved in that case. And what a nightmare that is. It just reeks of politics left and right. But, you know, what happens if the person who prosecuted that case as one of thousands that they did is now a judge, or a member of the state legislature, or even a congressman? You know, what happens if he's now a very well-respected defense attorney? You know, what do you do in these circumstances? What's the level of proof of malice that you're going to have to come to show a Brady violation to be intentional? How will you show a Brady violation to be intentional? All sorts of things like this. And he kind of puts the question out there in front of us all and shows some of the thorny sides of the issue. Going on, Seeking Justice, over at Seeking Justice, Tom carries on with some of this a couple days later, and he's talking about, well, you know, there actually is a statute under the federal government, under the federal code, where somebody could be charged and put in prison for having done this sort of thing by intentionally keeping Brady information away from the defense attorney, keeping exculpatory information away from the defense attorney. And he goes on and says, you know, but how often are you actually going to have the intentional violation here? And how are you going to show it? In the end, he says, and I have to kind of agree with him with this, difficult as it already is to show an ethical violation, criminalizing Brady violations would appear to be a solution, in quotes, involving more an appearance of being tough than a substantive response to the problem. And we've seen that all the time. You pass a law which nobody ever is going to enforce, or is going to be so seldom enforced that it'll probably be forgotten, but everybody feels good about it. And then we get to simple justice. And over simple justice, Scott sees this situation and says, wow, this is amazing. Let's see what's going on. And, it's happening. There's somebody taking all these constitutional Brady issues seriously. And then he starts looking around in different papers, the Wall Street Journal, the New York Times, etc., and he doesn't find anything about it. And he's rather disappointed by that. And for a short comment of my own on Brady violations, for those of you who've never worked in a prosecutor's office, which I'll assume those of you who aren't lawyers and those of you who are defense attorneys haven't, it's amazing how less omnipotent and omniscious and filled with riches the Commonwealth Attorney's Office seems to be now that I'm on the inside. When I was on the other side, I was so certain that they could do everything and get everything and had the money all the money they needed. Now, not so certain. To be more serious about this, what you end up with in Brady violation, if you have a Brady violation, is almost always going to be either a difference of perspective. The prosecutor looks through it, and the case looks pretty plain Jane, straightforward to him, and he doesn't really see anything in there that's, favorable to the defense attorney. In the meantime, the defense attorney over here is working some angle. He's looked up a case from 1863, which he thinks will prove that his client is innocent because of some rule that was in this case in 1863, which has never been overturned. And there's something in the, something that the prosecutor has evidence-wise, or an officer has evidence-wise, which would help with this rule from this case from 1863, help that attorney make his case. But because the prosecutor doesn't have a clue that that's what he's going to get hit with when he gets to court, he doesn't know to turn that over. He doesn't know that the evidence he has is exculpatory. I know that's kind of a strange thing, but it can happen. And obviously, you are going to run into a difference of perspective here. A prosecutor's idea of exculpatory and a defense attorney's idea of exculpatory are probably going to be, miles apart. They just aren't going to see things the same way. And a lot of things which the prosecutor thinks are irrelevant are going to look awful exculpatory, or at least helpfully exculpatory to a defense attorney. They may be, minorly exculpatory, but the defense attorney, may need that minor exculpatory matter to have something to defend with. As well, it's not, a prosecutor who has 150 cases in his caseload and, doesn't have the time to memorize what's in every single one of them. He, discovery is done pretty much by rote, gets it out, doesn't put much thought into it until it looks like he's coming to trial, looks it up again, looks through it, sees what he's got to prep for his trial. That's all sorts of room there for non-purposeful Brady mistakes. I'd like to think that I've not made any, personally. I can't think of any off the top of my head that I've made, but I'm sure that if some defense attorney who really, really wanted to complain about me combed through every single file I did and looked, he could find something that actually most of the time I've done open file policies, so that probably wouldn't apply to me, but if I had a closed file policy, would be able to comb through files and find something that I had not turned over that he could claim was exculpatory. It's going to happen. And, well, it's just going to happen. And on top of which, the prosecutor's also held responsible for what officers have, what information officers have. And, you've got 10 officers involved in a case, in a murder case, and, Officer A and Officer B file a report, and 2 days before the trial, you find out that Officer X, who didn't really file any of the reports or anything, knows a piece of information that probably should have been gotten to the defense attorney earlier. Well, that's not done intentionally. That's done. It's an error. The officers are working on 30, 40, 50, who knows how many cases of their own. I'm talking about investigators here, not the beat cops. They're working on their cases. Prosecutor's working on his case, and some officer who just was tertiary, who nobody thought really knew anything about the case at all, who, just happened 2 days later to talk to some grandmother who saw something which, seems to contradict the prosecution's evidence. It may not get to the prosecutor in order for him to turn it over. That's just a reality. As in faults, faults will happen. Now, I know that there are going to be people out there that say, oh yeah, but there are prosecutors that withhold evidence purposely. There may be. I mean, let's face it, some people can get wrapped up in things, and some people can just be evil. I don't think the majority of people are. I think most people try to play by the game, play by the rules, the way they're laid out. Same thing for officers. Yes, I know there's going to be some people out there that are going to see this and say, but Officer X withheld that because he knew it was going to hurt the case. And he knew that if he told the prosecuting attorney would have to turn it over. Well, that could happen. But you know what? Most of the time, at least well-trained officers know this sort of thing, know the kind of problem that can cause, and they don't want somebody who's been in jail for 10 years for a murder to get out because of something stupid like that. So they're likely is not going to turn, well, not likely is not, they're going to turn it over if they know that it needs to be turned over. Yeah, there's going to be bad cops. Yeah, there's going to be bad prosecutors. There always have been, there always will. It's the same thing. There'll be bad judges, there'll be bad defense attorneys, there'll be bad cops, and there'll be bad prosecutors. There will always be some bad apples. But the majority of the time, the problem isn't going to be from that. The majority of the time, what would be considered a Brady problem would be, from be a perspective problem and or a negligence, not even necessarily negligence, an overlooked problem. And that's kind of where I feel Brady is. Now, in Virginia, I think that if you purposely withheld evidence that was exculpatory, supposed to go to the defense attorney, I think you could probably be charged with obstruction of justice in Virginia, which is a misdemeanor, class 1. I can't think of any felonies off the top of my head which would get you there, but there's a misdemeanor you could be charged with. And as Tom pointed out in Seeking Justice, there apparently is a felony. I haven't checked into that, but apparently there's a felony that can be applied. So it's not like there's not already punishment. It exists. It's just a matter of whether or not it's actually affecting change or affecting anything at all, which apparently it isn't. Good news is, in Dallas, they have a prosecutor now who thinks that ethics and ethics are important and we should play by the rules. And that's a good thing. I'm not sure that we need any more laws against Brady violations, but I'm not in the legislature in Texas. I'm not even in the General Assembly in Virginia, so I don't get to make those choices. Somebody else will. And with that, ladies and gentlemen, I think we've completed our Cltv for the day. I hope you've enjoyed it. I hope I pointed some interesting facts and stories to you, and that my commentary made some sense. I'll see y'all next week. Have a good week now.